The warmth of summer calls you out for fun in your Geauga Park district. Venture into the great outdoors, 25 parks with a huge variety of hiking, biking, and fishing opportunities for all ages and abilities. Your next adventure starts now at geaugaparkdistrict.org.
All rise. The Geauga County Court of Common Pleas is now in session. The Honorable Carolyn J. Paschke presiding.
Good morning. You can be seated. It's Monday, June 10th, 2019. I'm Judge Paschke. We're on the record on case number 19C83, matter known as State of Ohio versus Gale and Ritchie. Ms. Ritchie's present in the courtroom today, and she's represented by Attorney Stephen Bradley. Mr. Pleads, the Geauga County Prosecutor, is present, as well as Mr. Burley. Before we get started today, I just want to, there's a number of people here in the courtroom, and I want to ask that everyone stay in the courtroom until we're adjourned. So if anyone would like to leave, if anyone does not want to wait until we adjourn, you can leave now. Okay. Mr. Pleads, could you introduce the case for us, please?
Thank you, Your Honor. We're here on case number 19C83, State of Ohio versus Gale Ritchie. The defendant was indicted by the Geauga County Grand Jury on June 6th, count 1 being aggravated murder, a felony, and count 2 being murder, a felony. And we are here for initial arraignment initial appearance, as this is a direct indictment, and I believe the defendant has waived the right to a separate arraignment. We're proceeding with that also. Thank you.
Thank you. Mr. Bradley, can you and your client approach the bench, please?
Certainly.
I'm going to ask that Ms. Ritchie stand on the side closer to the court. So that's good. Thank you. All right. Ms. Ritchie, have you received a copy of the indictment?
Yes.
And have you read the indictment?
Yes.
Do you understand the indictment?
I do.
Mr. Bradley, on behalf of your client, do you waive a formal reading of the indictment?
We do, Your Honor.
All right. So I'm not going to read that to you word for word, but I do want to go over with you the maximum possible penalties for each of the counts, okay? All right. Count 1 is aggravated murder. If convicted, that could carry with it a life sentence with the possibility of parole after 20 years and a maximum possible fine of $2,500. Count 2 is murder. If convicted, that could carry with it also a life sentence with a possibility of parole after 15 years and a maximum fine of $15,000. Do you understand those penalties?
Yes.
Okay. You have the right to counsel. You have the right for a reasonable continuance to obtain counsel. If you cannot afford counsel, counsel will be provided for you at the state's expense. You have private counsel here with you today. If something happens in your financial circumstances and you're no longer able to afford private counsel, counsel will be appointed for you at state's expense. You have the right to remain silent. You have the right to a jury trial, and you have the right to reasonable bail. Do you understand those rights?
Thank you.
All right. Now I have. There's something.
Yes, Your Honor. With the aggravated murder, it's a potential $25,000 fine. Is the maximum.
Oh, did I misspeak?
Yes, you did.
I
Sorry.
apologize. You understand that correction that Mr. Fleisch just made?
Yes.
Okay. All right, I have the designation of trial attorney here that is filled out by Mr. Bradley. So we have that. And I have here, Ms. Ritchie, a waiver and request form. This indicates that you understand you cannot be called upon to enter a plea at your initial appearance, but that you're waiving a separate arraignment and requesting to enter a plea of not guilty at this time. Is that correct? Yes? Okay. And I'm going to show you the form. Is that your signature toward the bottom?
Yes.
All right. Okay, so I'm going to accept your plea of not guilty, and we're going to assign a judge to your case, okay?
Judge David M. Andre.
Okay. Your case has been assigned to Judge Andre, which means your future hearings will be upstairs on the second floor in front of Judge Andre. Okay? All right, you can go back to your seats now. All right, Mr. Place, does the state have a recommendation regarding bond?
Yes, Your Honor, we do. The state does acknowledge this is a difficult matter for bond setting, given the circumstances of the case. But obviously the purpose of bond, primary purpose, is to secure appearance. The state does acknowledge the defendant has a lack of criminal record other than this incident and another incident I'll mention. And the state does acknowledge strong ties to the community by the defendant. However, the defendant is facing a mandatory life sentence for both of these charges. The defendant did confess to this crime, and the defendant also confessed to committing a similar crime that is currently being investigated in Cuyahoga County. So given those circumstances, the state would recommend a $250,000 cash surety or 10% bond, and if the defendant does post bond, that she be ordered to have GPS location tracking at her cost, at the defendant's cost, pretrial release with weekly contact with the pretrial release officer, that she not be permitted to leave Ohio, and that she surrender a passport if she does indeed have a passport. Thank you.
Thank you. Mr. Bradley?
Judge, as Mr. Flays pointed out to you, the primary purpose of bond is to ensure her appearance at all subsequent stages of these proceedings. And as he points out, there's unusual circumstances to this case. The offense conduct relates back some 26 years. She has long-standing ties to the community. She's married. Her husband's in the back of the courtroom, fully supports her in this case. She has children. She owns a home. She has extended family in the area. She does not have a passport. They certainly have means, but somewhat limited means when you consider they need to pay for a defense here. And I would suggest that a $250,000 bond would do nothing more than create a financial hardship to Ms. Ritchie. So we would ask you to consider something along the lines of a $50,000 bond. When you take into consideration the conditions of bond that the prosecution has proposed, GPS monitoring, regular contact with the probation department, etc., together with, for example, a $50,000 surety or 10% bond, that would more than adequately ensure her appearance at all subsequent stages. I would also note that she was arrested having left my office to consult about possible representation before she, of course, knew that there was a warrant for her arrest. The point being is that, you know, she was preparing to retain counsel and deal with these charges. And that's certainly a clear indication that it's not her intentions to go anywhere. She's going to stay where she's been her entire life and deal with these charges. So we would ask you to consider something more along the lines of a $50,000 10% bond. Thank you.
Thank you. All right, I'm going to set bond at $250,000, 10%. And Ms. Ritchie, I'm going to order our standard bond conditions. You're ordered not to possess or consume alcohol or drugs unless prescribed by an MD, a DO, or a dentist. You're ordered not to enter bars or places where alcohol is served as a primary source of income. You're ordered to submit to random alcohol or drug testing by means of breath, blood, or urine sample. You are ordered to report to pretrial release immediately after this hearing and one time per week, either in person or by phone as a pretrial release officer directs. You're ordered to obey the laws of the state of Ohio and not leave the state of Ohio without permission from the court or from your pretrial release officer. I am going to order GPS monitoring at your expense. The cost for that is $9 a day with $100 for the installation. I heard Mr. Bradley indicate that you don't have a passport. In the event that's not the case and you do, you are ordered to surrender your passport. Mr. Bradley, I do have the address at Upper Valley Drive. That is a correct and current address?
That is correct.
Okay. All right. And I also have an indication that jail has already taken care of fingerprints and photographs and a DNA sample, so I won't order that at this time. Mr. Pleads, is there anything else we need to address?
No, thank you, Your Honor.
All right. Mr. Bradley, anything
No,
else?
thank you very much.
All right, we're adjourned. Thank you.